Hello and welcome to Family Law and More. We are your hosts. I am Lisa Edmonds.
My name is Bella Tate.
And I'm Isabel Hawkins.
And today we are joined by Louise Tickle. Louise is an award-winning journalist specialising in reporting on domestic abuse, family courts and child protection matters. Louise works for Tortoise Media, which does slow, in-depth investigations. She also writes for The Guardian on education, social affairs and family law. She is a committee member of the Transparency Project, which aims to promote greater understanding of family law. Louise, welcome.
Thanks for having me.
Now, you've been very busy recently. We can see that you've highlighted a number of family law cases, one close to home to Unit Chambers here in Liverpool, where a 7-year-old boy has been abducted by his father and taken to Saudi Arabia, where his mother says that she had warned the authorities, including the family court, that that was going to happen. You've highlighted the tragic case of Finlay Bowden, where the family court returned Finlay to the care of his parents, who then went on to kill him. And of course, about Becky, a child who has been locked away, where you put the spotlight on what you call Britain's modern bedlam. Louise, can we start off by asking why you think it's important to bring these issues into greater focus?
Because when the family court is involved in any case like this, it wields the most enormous powers, and it has powers to protect people if it chooses to use them. And I think when powers are exercised in that way by the state, it's absolutely necessary that the system is scrutinised, and not just the decisions that are taken, but the process by which those decisions are reached. And I've said in the past, I don't know any part of the state that operates better in secret. We wouldn't have the police operating in secret. We wouldn't have hospitals operating in secret. We don't have councils operating in secret. Government doesn't operate in secret. And where it does, things often go wrong. I think one of the biggest problems that the family justice system faces is that when you operate completely in a bubble with no independent scrutiny, norms can become embedded, which potentially don't move on with the attitudes of the outside world. Things can become, and this isn't just family law, this would be any system that operated in secret. Ways of behaving, ways of managing a process, things that become acceptable. I see this, just a tiny example. The number of times I've seen local authorities completely flout orders of the court to submit documents on time. And this might seem like a small thing, but it fundamentally affects the process because it introduces delay, and delay can be determinative of an outcome. And this I see on such a regular occasion. I see judges doing their nut about it. And I can't write a story just about, councils flouting an order to submit papers on time, but I see it happening so often. And in fact, recently I was able to just insert something about a council that had done that, and a judge who had inserted a penal notice. She was so angry on the third occasion. So that's why I think it's not the individual stories that I'm focusing on here. I think it's bringing the operation of a whole system into focus that I'm interested in order that people can reflect on it, and hopefully that it should become better.
What our listeners can't see is that we're all connected on Teams. And as you were talking about delay with parties generally, but I think it's fair to maybe spotlight local authorities that they regularly don't comply with those directions. There was a collection of nods going on. So I think from our point of view, that is something that we engage with day in, day out. And there definitely isn't any, I would say, accountability for ignoring court orders. And I'm often left asking myself, well, if nothing changes, nothing changes. And I've seen some judges try and remedy that situation by a penal notice, as you've just highlighted, cost sanctions on occasions. But obviously, when you're dealing with children and you're trying to get parents to, outside of the court environment, work with the local authority, I think judges are very aware of that and want to make sure that they're not doing anything that impacts on the dynamic of trying to establish some sort of working relationship.
The problem, of course, is, and I've thought about this a lot over the years, these kind of 8.5 years now since I went to Bristol Family Court the first time. And all judges and all the barristers and all the solicitors in a case are focused rightly on that individual child or children in that case. And their paramount concern in law is the welfare of that child or children. As a journalist, I come in from the outside and I'm looking at an entire system. And it's a little bit like with your own children. If you're inconsistent in the moment because it feels sort of right at that time for various reasons to flex, they take advantage next time. And so what happens is overall the process becomes sullied. It becomes more dysfunctional because poor practice and poor expectations are introduced, and nobody, for reasons that I understand, is often willing to take a really strong stand against, I've seen a judgment where a judge said that a social worker had directly flouted an order. Nothing happened to that social worker. They were in a council that had been rated inadequate. And it makes me wonder, that is why I think scrutiny is important. And that's why I think it's important that somebody from the outside is able to call it out, because my duties are not the same as your duties in a case. My duties are to explain a system and where things are falling down. And so where I can do that, I try. But there seems to me to be nobody looking at the overall health of the family justice system, because it operates in private. Each case is individual. Each judge is individual. Even any appeal only turns on its back. And so there's no oversight of an entire system's operation, which I think is really unfortunate.
Just to jump on that point of delay, Louise, I think it's really important also to highlight that delay does come through local authorities, for example, not complying with orders, but also just the court lists are so packed. And in particular, that phrase that you use, delay, can be determinative of a case. I completely agree. And actually, I think that might even be more prevalent in private law, because private law is often the one that's pushed to the back burner. I was on a final hearing yesterday that had its final hearing relisted 3 times and was 8 months later than it should have been. It was a very easy final hearing, and that it wasn't determinative, but in many cases it could be. So the issues are with the parties, but it's also with the system itself.
I mean, I've spoken to loads of people, as you will have done, whose level of, there's all sorts of things that are affected by delay, but whose level of distress, whose attitudes to, perhaps in private law cases, the other parent, whose family dynamics have changed so greatly within that period, and things have changed for the child within that period, that it could easily be, for instance, that a father who had an interim order saying no contact after 8 months might not be able to argue that he had a strong relationship with a child, because he didn't by that stage.
Absolutely.
And really shocking. And that's why I think that I understand that the family justice system, as so many systems in society, is completely on the edge and crammed with cases. And that's, I think, why I always try, and I always do. It would terrify me not to submit papers when a court had ordered them. And when I've been representing myself, I've done it. And it's even nicer when I'm being represented and I'm embarrassed to kind of think about getting position statements in. But the idea that a local authority, with the powers it wields, with the influence it has, with the resources at its fingertips, albeit stretched, can't get it act together to get papers in on time, fundamentally shocks me, because they both wield the power and they undermine the ability of the other parties to engage in the process when they delay, when they don't observe orders. And I think that is why judges do get so angry, because they understand.
I don't know whether you're aware, Louise, but here in Merseyside, we now have a practice note from our DFJ that has set up a non-compliance court. So I think there's 1 day a week allocated for parties that have not complied with a court order to go in front of that judge. So if we use, and we're talking, I know in general terms, but local authorities as the party within care proceedings that is more likely to default on a court order, what's happening at the moment is the local authority only go and see the DFJ to understand why there hasn't been non-compliance. And there's been some discussion, again, that's taking place in secret, if that's the right word, as in the absence of the other parties. But the purpose, we're told, for that type of hearing is so the court can better understand how and why things are going wrong within the local authority to try and help and support them put things right. So this culture of non-compliance and getting away with it is going to stop at some point. But I think the one thing that I'm interested to know is sort of how that data is going to be pulled together, who's going to evaluate it, who's then going to set out the pathway for reform. But I don't know whether you have a view on whether you think that is a good start point.
Well, it's an interesting approach, and I kind of laughed when you said it because it sounded, like going to the head teacher's office. And maybe it focuses minds, but I would be fascinated in the data. One of the things I've really noticed as a journalist is that getting data on anything that happens in the family justice system is incredibly difficult. And it means, for instance, that when you're trying to pitch a story to an editor and they're saying, well, how often does this happen? Usually all I can go is, well, I know a few anecdotal cases and I'm getting, I'm taking soundings from lawyers and it feels to me like this is a problem. But I think that HMCTS, is that right? HMCTS?
Yeah.
I think HMCTS is potentially either not resourced or not interested or not motivated to gather data which would be useful both to the family justice system and, I guess, incidentally, because they wouldn't be gathering it for us, for journalists to be able to see systemically what's going on. I think it's a problem that judges have talked to me about as well. Repeatedly, I'm told that they never understand the outcome of their decisions because they get no feedback. And I think it's a really terrifying place to be. If you're the person who is empowered to make really draconian decisions, you're doing very significant things to the shape of the family, and then you have no idea whether that's worked in any way.
Yeah.
I think that's an extraordinary situation for a major organ of the state to be in.
Just picking up on that point about the family court operating in secret, we know, of course, that the president of the family division, Sir Andrew McFarlane, has stated that he's committed to getting a healthier balance between protecting the confidentiality of the parties and also restoring confidence from the public. And he's announced the 12-month pilot programme on the 30th of January, which has, I believe, been extended this month. So in your opinion, Louise, I think I know the answer, but have the family courts gone as far as they can in terms of trying to strike that balance and trying to get a better system of transparency? What's your view?
I think the family justice system has gone as far as it can right now to increase transparency and scrutiny to some degree in the system. I know that there has been a lot of heavy lifting done by Mrs. Justice Leven and Barrister Jack Harrison, who had travelled the country talking to judges and lawyers and trying to persuade them and get them on side with the idea of a pilot, which is still only in 3 pilot court centres, Cardiff, Leeds and Carlisle. There are reasons why those court centres were chosen, but...
That was one of my questions this morning, actually. What was it about those court centres?
Okay, the rationale is that anonymity is the biggest issue.
Yeah.
If that can be protected effectively, then that will be a success. There are different issues to do with anonymity in different parts of the country. So if you were in rural Norfolk and you were a Sudanese family, there would be different issues that a judge and journalists and lawyers would all have to engage with to effectively anonymise that family. Some of those things might actually be very salient to the case.
Mm-hmm.
And so hence they needed a rural place. Hence, I guess Carlisle must have stepped up. They needed a metropolitan centre because they needed somewhere very different. So that could have been Birmingham or Manchester or Leeds or Bristol or London. They chose Leeds, and they needed somewhere in Wales, and the main court centre is Cardiff. I have to say that for journalists, trekking up to Carlisle is an ask beyond most editors.
Some barristers have that view.
Yeah, I mean, lovely part of the world. I love going to Cumbria. In fact, I'm working on a project with the Bureau of Investigative Journalism, which got funding. And so a journalist, Hannah Summers, who also reports a lot on the family justice system, just went for a 4-day fact-finding rehearing in Carlisle. it was a private law case. She went before the private law bit of the pilot had come into place. So she still had to make an application, and we still don't know if the transparency order will be affected in that case. And that was a very big investment, because if we don't get the transparency order, and if she can't report on a rehearing, which was a very interesting one, a tenth of our journalistic budget for the pilot, the Bureau's budget that it got charitable funding for, will have effectively been blown. We won't be able to report in a useful way on that case. And so that's the level of investment that it takes to send a journalist to Carlisle or Leeds or Cardiff. And yet, it's very important that it's not just London that gets covered. My patch, Gloucestershire, and I've been to Bristol Family Court a lot. But it will never be. I mean, the thing that's interesting is that one of the big concerns that I kept hearing when the pilot was being proposed was, are all these journalists going to fetch up at the courts and write sensationalist stories about people in desperate situations? And all the journalists that were in these kind of media engagement meetings were just kind of looking at the president going, you have no idea the financial strictures that we're under. We keep trying to tell you that editors are not going to be sending journalists on spec into cases, that they can't report at all. But even with a transparency order, it's not the same going to a family case as going to a criminal case. They are extensive. They last for a long time. The hearings can go on over several months. You might have to keep going back. If what you're going to get out of that is a 1,500-word feature, it doesn't make sense for an editor to send you there. So Sacha Berg at the BBC persuaded her editors to let her have coverage over a whole week on the Today programme and other BBC news outlets. And so she and her producer were able to Leeds a lot. It was a major investment. And then they covered various different cases over a week and got, I think, 14 transparency orders out of the 15 cases they attended. But that's the BBC.
Yeah.
They have resources. It's different for other outlets. It's a much more finely judged decision.
And so with that being said, do you think that the pilot as it's set up at the moment is working, is effective?
I think the biggest thing that will lead to whether this pilot succeeds or fails is whether listings can be sorted out. As a journalist, looking on CourtServe at listings is utterly impenetrable. I've been following the family justice system for, as I said, 8 years. I still really struggle. Brian Farmer, who's the kind of in-house journalist at PA Media, he understands lists. But I'm always ringing up barristers I know to go, what's this case about? I don't get it. And Jack Harrison at the Transparency Implementation Group has been working really hard to try and get lists to be more transparent. But if you go to an editor and say, I want to go and see a private law case that involves allegations of domestic abuse and parental alienation, and they say, great, crack on, you go and find a case. Unless you have somebody who comes to you with a case, you can't work out what's going on.
No.
When I created a sort of proposal for a pilot reporting project before the one that was created by the president, and I worked on it with Lucy Reed, who's a barrister in Bristol, the founder of the Transparency Project, and we came up with a way of kind of adding to a list just to give you an idea of what was involved in the case. And that wasn't adopted. And we explained and warned that it wouldn't work. And Sancha went into the designated family judge in Leeds and just said, without a better idea of what these lists mean and of what's happening tomorrow, this pilot will fail. I think something is going to happen to make it a bit better. It's not happened yet. I know Jack has worked really hard on it. So that is one of the main things. I also think it needs to be in more court centres. It's not realistic to expect journalists to trek to Carlisle. Yeah. Most of the journalists in the north of England are in Manchester, not Leeds. I went and trained them in the transparency pilot rules, but I didn't put the training course on in Leeds because I knew that the journalists weren't there. I trained them in Manchester. I did a training course in Cardiff and it was really nice. We got a lot of people there. But I'm doing another course on the 22nd of June and I'm holding that in London because there were so many requests from London-based journalists to do the course and I couldn't get them to trek up to, Manchester or Cardiff.
Well, I think a lot of professionals, again, would echo your frustrations at the level of the list, the quality of the lists, how they are produced. You're actually highlighting a lot of the things that I think internally we are frustrated with. So it's interesting to see when you've got a journalist and, professionals coming in, looking from the outside. We are also frustrated by those same things.
Yeah. And Louise, do you know, because I wasn't sure, who is going to assess the outcomes of the pilot project? To inform what's going to happen next and whether it's going to be extended?
Well, someone is. I'm not sure who is. we are assured that there will be an assessment, and I think it's going to be sort of happening in-house through either the Transparency Implementation Group, through a subgroup of that, or via an outside organisation that they commission. There will be an assessment. I'm really sorry, I can't tell you more on that.
Well, we're all waiting with bated breath, I'm sure.
Maybe the media should also do an assessment of its view of the effectiveness of the pilot and feed that in.
Yes.
I think
that would be interesting.
I think that would be critical, actually.
Yeah, I agree.
In our next episode, we will be celebrating Unit Chambers' 3rd birthday. Join us for a special episode where the legend Anisha Katona, MBE, CEO and Executive Chef and Development Chef of Mowgli Street Food, and in a previous life, a family barrister in Liverpool, will host the podcast and interview Unit's very own CEO, Lisa Edmonds, and Executive Chairman, Roger Draper, all about their exciting journey on the development of Unit Chambers and what the future looks like. Join us then.
So Louise, we've touched a little bit on this, but I'd love to ask you a bit more. There's lots of key stakeholders that engage in the family courts: lawyers, social workers, guardians, treating clinicians, experts, etc. And is there a risk, do you think, that striving for this kind of accountability, and that might include naming and shaming professionals, can create a risk of other families losing confidence in that system, those people, and the professionals becoming subjects or subject to vigilant behaviors? And we've sort of spoken about the stretched resources. And I guess my question is also centered around whether or not this is more systemic problems with lacking of resources, or if this is individual problems with individuals making mistakes and how that will be approached.
I have different thoughts on this. It was interesting to me to see that when Mrs. Justice Leven released to the BBC, the Telegraph, and one other outlet that I can't remember now, the papers on the Finley Bowden case, she obviously did allow them to name the Kafka's guardian, the social worker involved. I think those were the two main people, and the names of the magistrates, although judges would normally be named. You can see that I'm sort of...
I struggle with it.
I really struggle with it. I think I was at a conference in Nottingham the other week, and we were talking about this issue as well. I am uncomfortable with saying a blanket no to naming professionals. But I think unless there has been active deception or grossly reckless or maybe even potentially criminal practice, I would be reluctant, because over the years I have come to know the effect on professionals who are trying to do a job in very difficult circumstances of being named. On the other hand, I will always recall two judgments by His Honour Mark Horton about 3 social workers who he found to have deceived, lied, fabricated, and their manager had kind of gone along with it and kind of gone to court and basically made excuses for them. And he named them all. And there was an internal investigation within the local authority, which I think was Hampshire. It found they'd done nothing wrong, apparently, although no details were released. They were referred to the regulator, the HCPC at the time, and that didn't go any further because the Transparency Project did a lot of work on trying to do a freedom of information request to find out the rationale for not taking it further. And so now the situation we have is that all 3 of those social workers have been promoted. They've gone to different local authorities.
Wow.
And one is the chief executive of Slough Children's Trust. And so she is now effectively the Director of Children's Services of a children's trust, which took over the local authority children's services in Slough because they were so terrible. Co-appointed by the DfE. I did lots of freedom of information requests to find out if this was known about, on what basis she was appointed. And I was completely stonewalled. And so then I'm left asking the question, if a judge ever has to call that chief executive into his or her court on the basis of there having been very poor or deceptive practice in that local authority, how can he or she ever believe what she says, ever have confidence in what this person, who is the ultimate stopgap for safeguarding children in that local authority area, that what she says to them? And so part of me thinks, well, it made no difference anyway, naming her. She's flourished. And the other social workers have been incorporated. So, yeah, it's a tricky one. But you're talking about the risk of families losing confidence in the process.
Well, a bit of both, because I think obviously, like you've just highlighted, it can affect, well, potentially not affect, but you'd think naming and shaming a professional would affect their ability to be promoted, etc. But families will continue to work. That social worker, that's not the only family they're working with. So if they're named and shamed and they're continuing in their position, then the rest of the families that may or may not read that news article is going to lose all faith in them. So,
well, maybe they should. I mean, doesn't that seem like a pretty justifiable position? If you had that a doctor, as we know, a doctor was branding his initials, a surgeon, on the internal organs of people that he operated on, and he was criminally prosecuted, but I think he was also struck off. Why would you trust that surgeon?
Yeah.
There's a reason why people are sometimes named and shamed, and it's to warn the public that they are not fit to do their job potentially. Now, the reason that I hesitated at the beginning about saying whether I thought that should always happen is that we all work in contexts that we don't have control over. If I was a journalist in a very poorly staffed newsroom, without editorial oversight, without access to a lawyer on tap, then I would make mistakes. I would libel people. I potentially might commit contempt of court. And that wouldn't just be my fault, as long as I hadn't intended to do it or hadn't been, ridiculously reckless. So I think in a lot of cases, it's not right to name people. And I was surprised that Mrs. Justice Stephen allowed that in the Finley Bowden case. I don't mean to say that she was wrong. I just mean it surprised me. I was interested in the rationale, and I might ask what the rationale was, or ask the papers for the judgment to be released. But I think in some cases it's necessary. And if families lose faith, then fair dues, they lose faith, but they might also have greater faith in the long term in a system which protects from people who practice in a way that can destroy their family.
Yeah, I've had a couple of cases where parents have gone on Google and looked at, in one case it was a doctor, in another case it was a social worker. They had each undergone disciplinary proceedings, and that was out there in the public domain. Happened some time ago. They clearly retained their role, their job. And the parents, two different cases, were coming to court waiving the sort of outcome of their research and their homework. And it was really difficult because standing in their shoes, completely get it. But going in front of the court, a judge wasn't particularly interested. And ultimately, the judge would say no power because I can't decide which social worker is allocated to a case. I can't decide who the treating clinician is when you attend at A&E. So I think, those sort of dynamics then really kicked in because the process did nothing to iron out that tension, to try and move through those barriers. It was just left, well, that's not my problem. And the parents then really struggled.
I'm sure they did. And this is, I can't believe that the right approach to that, however, is for parents to be less informed. Why, information is power. At least it's enough power to be able to say to their representative, their barrister, look and see that this disciplinary process has happened to this doctor. And then the barrister could look and see whether that disciplinary process if the complaint had anything salient to do with the case that they were involved in. If it didn't, then, well, it didn't. If it did, then at least they get to make the argument in court. Sometimes that's the best.
I think it's reassuring to hear that in terms of when we're talking about naming professionals, it's a high bar that you would expect for them to have crossed in terms of their own actions for them to be named. Because I think a lot of times when we do have these non-compliance courts from local authority social workers not doing it, it is resource issues. So I think that one of the really important things that this project is going to do is going to highlight the massive lack of resources that there is out there. The system is creaking out, it seems, in pretty much every department. So, like I said, reassuring to hear that the naming of individuals, because I think that this is a systemic problem with, of course, individuals making mistakes in certain scenarios, but I think it could really affect retention or even bringing on of new professionals in these roles if they are worried about making a mistake and then being named in a news article.
But I think that's where really... Sorry, Louise, I was just going to say about the Finlay Bowden case, because from the information that we have available to us, so the articles that have been produced recently, it would appear that on the facts, professionals didn't do anything wrong per se. I think Mrs. Justice Leven comments that she thought ultimately the decision of the court was reasonable on the evaluation of the information and evidence. So I agree with you. I think on that particular case, there's an unknown from a judicial perspective as to why it's been considered appropriate. And I think it would be helpful to dig a bit deeper.
It may be that in cases that are so serious, that particular judge or judges just feel that if a child has died, that is the most serious failure of any system, whatever the reasons, and that the people involved, they are professionals. These are not bus conductors or milkmen. They are highly trained professionals, and as such, we are accountable. That may have been her rationale. I don't know. I'd be really interested to see. But just talking about the Finlay Bowden case, to me, what the reporting kind of showed the most was the desperate effect of lockdown social work on assessment of children and on the court system. That was a case heard by two magistrates over the phone. Now, we've all attended phone hearings. I think phone hearings are really unsatisfactory in ways that even, Teams hearings are not. I think Teams hearings, a lot of things can be okay. And I've been in a lot of them now, way more remote hearings than I ever went to in-person hearings. But I think the phone hearings I've attended have been really unsatisfactory.
So, Louise, to wrap up this podcast session, it seems to me as though we could go on for a long, long time. From our perspective, so advocates, as the pilot is kicking in, we're nearly halfway into it. What are your expectations, speaking on behalf of journalists and legal bloggers, when you rock up at a court hearing? What are you wanting from us?
Oh, I want the lawyers to smile at me and come and take my hat and not think I'm like the Antichrist. Mostly they do. I've mostly had really good experiences with lawyers.
Good.
I have had some bad ones, and they sting, and they, you kind of hug the bad experiences to you because they make you feel awful. But mostly, I've had really nice experiences with lawyers who, at the beginning of when I was reporting, journalists, well, still almost never go to court, but almost nobody had ever seen a journalist. And so everyone is kind of like in this world where you kind of don't quite know what's going on or where the barriers are or where the boundaries are and what should happen. I mean, having a conversation with a journalist before a case or in a break about what they might want to do in a case that just should be a normal professional conversation. Do you want to report? Is there anything you specifically think you don't need to? This might be sensitivity. And you can have a conversation. Quite often you can come to either a complete agreement that you can present to the judge, who can then decide, or, you can just narrow the issues, and there can be one or two things that the journalist thinks is editorially important that you can't agree with, and then you have to go and make your argument. But it should all be really civil. I still remember a time in I think it was Court 34 in the Royal Courts of Justice, and Lady Justice King and Sir Andrew McFarlane could see that we, had not got to an agreement. They said, well, we're just going to rise, and you can see what you can come to. And so we were then literally kind of horse trading between whether I could say several months or 2 months or whatever it was, 3 months, about when a child had been, locked up in an unsuitable placement. And, you have to do it with a smile, because it's our jobs. That's all it is. And I just tend to find that it can be really reassuring for clients too, if you're either introduced to them by their lawyer and they say, look, this is a journalist who's going to be in court. They've got the right to be there. Unless it's a pilot court, they can't report unless they get permission from the judge, and you've got the right to have objections, or we can have a conversation about it.
Yeah.
Most of my reporting that's not family court is really sensitive reporting about domestic homicide, domestic abuse, sexual assault. I don't tend to want to report stuff that people would find extremely painful. It would have to be an extremely high public interest bar for me to think it was worth fighting that point.
Yeah.
I think about the Kate Griffiths case, where her ex-husband, Andrew Griffiths, the former MP for Burton, had been found in a family court in Derby to have raped and abused her and coercively controlled her over the entire course of their relationship. I made that application to be able to report with Brian Farmer at PA without knowing what Kate's position was. We didn't know Kate's position because we weren't in touch with her until about 2 weeks before the hearing. And had she said she didn't want, in theory, any, but particularly the sexual assault findings to be made public, we couldn't have gone ahead with that bit of the application. Not legally, because it wasn't a criminal case, but ethically, we couldn't have gone ahead with that. So I'd say talk to journalists. We are generally reasonable.
Talking's always good. Louise, thank you very much. As you know, we end each episode with a game of Roll That Dice. Are you happy to play?
Go for it.
Okay, I'm going to roll. And we have career highlight.
Oh, okay. Well, that's funny because I was thinking about this last night, and it's really difficult because I'm in a job where people are really trusting you with some of the worst things that have happened to them, as you are in your jobs. And I think, overall, the fact that people trust you enough to go through the trauma of telling you things that have destroyed them and their families is, overall, it's the career highlight. But I suppose in terms of the thing that I have had to fight hardest for, it was the Kate and Andrew Griffiths publication of that judgment, because it was a legally very complex argument. I had to work on it with Lucy Reed, now Casey, who was my barrister, who I went to one day just going, "Can you help me?" And she was like, "It's going to be really hard." But, we got there. It took a year and 7 days, but we got there. So that was the highlight.
Excellent.
Brilliant.
Well, that brings this episode to an end. Louise, thank you once again. We will be back in a couple of weeks with Daniel Thomas from Chroma, who will be sharing his expertise and experience on the power of the arts, how we can help realise children's potential, specifically those who have suffered with some trauma, through creativity. So please remember to subscribe, leave a review, and if you have any questions, then please send them to podcast@unit.law.
Thanks, Louise.
Thanks, everyone.